Welcome back. We are live tonight. We want to hear from you. What do you make of the release of ChannelOne to me? We just showed you some footages of himself, Justin Kodia, Frimpong, and then of course John Buedu, and then you saw Brian Champon, who we are told was one of the sureties. There's a second discussion around MPP leaders falling over themselves to show loyalty to Wontumi. So everybody's been there. Bawumia has been there. We are told Kenneth Japan was there. Educhum was there. Brian also helped to secure. So it looks like everybody in MPP who matters wants to show their support for ChannelOne. That will be a separate conversation. But Alhaji, let me take your final thought on the legal issue your colleague here raises. Why is CID, Yoko, and now FIC, we are told, interested in one man? It's almost like he says they are passing him on like football. It's a violation of his right. In your practice, is this normal for at least two institutions and a third? Because we were told by the majority whip that the FIC also has a dossier against Wontumi. Is that best practice?
So the first question is that which rights is being violated? So we need to understand which rights of Wontumi is being violated. The second thing is that these are institutions of states established with specific mandates. So there are jurisdictional issues to be overcome. So you have Yoko dealing with economic and organized crime and money laundering issues. So that's the specific jurisdiction that has been given. And that because it's a specific jurisdiction, my brother in the studio knows that where there is a specific legislation dealing with a matter, general legislation will not suffice if you use that for the purposes of dealing with the matter. So yes, there must be there is a Criminal and Other Offences Act. But because it's a specific legislation dealing with specific crimes committed by people, which crimes ought to be investigated, those institutions with those specific jurisdictions are better suited to investigate them. So you cannot see Office of the Special Prosecutor going to investigate an offense involving let me use the money laundering, because they had said in the case of Cecilia Dapa that the matter, their review of all the facts touching and concerning Cecilia Dapa fell within the ambit of money laundering. Never mind that they never found the predicate offense. But and if it was money laundering, it was the view of the special prosecutor that the proper institution to deal with that was Yoko. So as a lawyer, I will always advise my clients to subject themselves to the various institutions. You see, I've heard our people argue that they would have been comfortable with all the investigative bodies, which is a little different from what Honorable Tampuli is saying. He thinks that the CID should have been given the exclusive mandate to deal with Wontumi. I've heard others argue that, well, they would have been comfortable if all these institutions were seated around a table and investigating, or if you want, interviewing or having a conference with Wontumi to determine whether or not crimes have been committed under their various jurisdictions. And now say, well, that will be fishing. That will be fishing. I mean, if all the institutions are gathered around a table and trying to look for offenses that have been committed under their various legislative, arrangements or regimes, you will be exposing the accused person to undue harm. Undue harm. So, yes, it's unfortunate that Wontumi has brought himself within the ambit of many institutions.
All right.
The thing is that this is gratuitous. He for his own benefit, he needs to appear before all the institutions. And I'm sure Appear Kubi will advise him not to allow all the institutions together to subject him to an investigation, which answers or questioning which answers can help fund criminal activities in other institutions.
Fair enough. Let's go to the next issue. Talking of appearance. Ken Ofori-Atta has to appear before OSP, according to the special prosecutor. Let me give you a quick timeline of events. January this year, so this started in the early hours of this government. The OSP officially notified Mr. Ofori-Atta that he was a suspect in 5 separate cases and asked him to appear in person on February 10. So this is January 2025 we're talking about now. January 31, Ken's lawyers informed the OSP that he was abroad indefinitely for medical reasons and offered to represent him in his absence. All right? A week after that, February 5, the OSP rejected the claim of indefinite absence and demanded a firm return date by February 10, warning of legal consequences for failure to comply. It also reminded that legal representatives cannot respond to criminal charges on behalf of clients. So the OSP was having none of that, this idea of indefinite absence for medical reasons. So this was February 5. 5 days later, Mr. Ofori-Atta's lawyers submitted a doctor's note stating that he was undergoing tests and possibly surgery with no clear return date. Now, this was not addressed to anyone specifically. 2 days later, the OSP declared Mr. Ofori-Atta a fugitive from justice, acting on an arrest warrant. So they obviously did not recognize this doctor's note. 6 days later, February 18, Mr. Ofori-Atta appealed to the OSP to remove his name from the wanted list and for the first time provided a definite return date, which was scheduled for May 2025, which was just 2 days before this June 2 we are in. Now, the OSP accepted his assurance and subsequently took his name off the list. So in February 18, we appear to have come to some compromise that Mr. Ofori-Atta will return May 2025. Now, but after that, in March, Mr. Ofori-Atta then files a lawsuit against the OSP and the special prosecutor seeking, so the man himself in the position, seeking compensation for what he called an unlawful declaration of him as wanted and asked for the removal of related publications from the OSP social media. End of March, the Human Rights Court had an interim application from Mr. Ofori-Atta asking that the OSP be barred from declaring him wanted again. Now, the OSP has been waiting for May to end to act. So according to a summary of the facts that OSP put out, they said they expected Mr. Ofori-Atta to return today, 2nd June, in person to the OSP headquarters. We heard from his lawyer, Frank Davis, Ken Ofori-Atta's lawyer, that he is unwell and cannot return anytime soon. The OSP has stated that if he failed to appear, his name will be added back to the list. So today, if we can hear a quick excerpt of the Kissie Jabing OSP speaking about the matter, he declared or redeclared Mr. Ofori-Atta wanted and issued an Interpol red notice. Let's hear him.
The Office of the Special Prosecutor first notified Ken Ofori-Atta of his investigations in January 2025, although he initially cited medical reasons for his absence and pledged to cooperate. The Special Prosecutor said the former minister repeatedly failed to meet deadlines to submit credible documentation regarding his health status. According to Mr. Jabin, after months of non-compliance, Ofori-Atta's legal team eventually agreed to a June 2 in-person meeting. But just 6 days prior, they informed the OSP that their client had been diagnosed with cancer and will require surgery, subsequently requesting a virtual interview. The OSP rejected the special prosecutor. Following his no-show on June 2, the OSP officially relisted Mr. Ofori-Atta.
The OSP redeclares that Mr. Ofori-Atta is a wanted person and a fugitive from justice. His name is hereby re-entered on the OSP's list of wanted persons. The OSP will take all necessary legal steps to secure Mr. Ofori-Atta's return to the jurisdiction and to answer to the criminal inquiries against him. In pursuance of this, about 30 minutes before this briefing, I triggered processes for the issuance of an Interpol red notice for the location and provisional arrest of Mr. Kenneth Nanaya Ofori-Atta in whichever jurisdiction pending extradition or his surrender.
Mr. Jabin also provided updates on other high-profile investigations.
So, Mr. Kisir Jabin has re-entered or issued, for want of a better word, an Interpol red notice and declared Mr. Ofori-Atta wanted, which of course happened today. That timeline is the same timeline you have as well, right? So these are the facts as you know it. What do you make of where we are on this matter?
I think that I followed the interview that has been granted by Mr. Frank Davis,
yes,
who is Honorable Ken Ofori-Atta's lawyers.
Yes.
And he continues to insist that his client is still unwell.
Yes.
And is unable to respond positively to the invitation that has been extended to him by the OSP. Now, by and large, I think that there has to be some meeting of minds between the OSP and the lawyers of Honorable Ken Ofori-Atta, because they insist that the man is unable to come, to appear in person. Now, the law provides for other means of engaging him without necessarily having him appear before you physically. Under the Electronic Transaction Act, you can have a video recorded interview. Of course, there are instances where even an accused person or a witness in the course of a trial is unwell. The court can move to the locus to even take evidence of the person. In some instances, we call it preservation of evidence. The court can take evidence from somebody who is seen to be sick, and they are not too sure whether the person will be able to make it, and preserve the evidence for use at another date. Under the Mutual Legal Assistance Act, Act 827, there is also room for Honorable Ken Ofori-Atta to do another, electronic engagement, and it is permitted by law. And I don't know where he is right now, but he must be in the United States,
yes, from
what we realize. The United States is a member party to the Mutual, Legal Assistance Act. And if you check the schedule, you'll find that the United States is there. So it's easy for the OSP to engage. At the very least, Ken Ofori-Atta doesn't have to assist the OSP to prosecute him. He doesn't have any such obligation. In fact, every accused person has a right not to self-incriminate. So you can decide not to even cooperate with the OSP, but the OSP can still go on ahead with the case. Why is this lady who used to be a Maslock chief executive? I've forgotten her name. She was tried in absentia. All right? So you can go ahead, and go into the trial. But what is important for me is that there are options available for Ken Ofori-Atta to engage the OSP. So I think the OSP should take advantage of, this medium.
So do you think this declaration of him wanted and the red notice is then necessary? In
this era of digitalization, we should be able to see, some amount of, change. The OSP should take advantage of this digital platform, engage him. Let's see that, yes, he has... Look, in criminal prosecution, you must establish the guilt of the accused person beyond reasonable doubts. Give the accused person every opportunity, you understand, to vindicate his rights. You are not prosecuting because you want to convict. You are prosecuting because you want to put your case before the trial of facts, and then the court will make a determination. So it's as if Ken has been declared a criminal already even before the trial commences. So I think that the OSP may have all his cases, all his evidence and all of that right, but he should be able to agree to a suggestion that he should be able to engage Ken Ofori-Atta, wherever he is, via digital, platform, and see whatever evidence he's able to get from him.
Inusa, what are your thoughts on this saga?
First of all, Ken Ofori-Atta is not an accused person. He's a person of interest. He's a suspect. And that's why he's being asked to assist in investigations. The investigations is to grant him an opportunity to respond to certain matters that have come to the attention of the OSP. And a successful answer to those matters will exonerate him and let him walk away. If he fails to answer them successfully, he is then cautioned. Further investigations are carried out. And if those further investigations establish a prima facie, then he's charged for court. So this is the preliminary stage. 2, Ken Ofori-Atta is not an accused person. If he were an accused person, he would be entitled to a presumption of innocence. But he's a suspect. He's not entitled to a good name, because matters have come before the criminal investigative authorities, and they believe that he must assist in investigating them. So, and that is why a red notice has been issued. Has been issued because as a responsible and dutiful citizen of the country, he has a duty to assist in investigations. If he is charged, he can decide, he can elect not to write a statement or not to speak on the matter. But he's just assisting investigations. Now, and no one has said that so far Ken Ofori-Atta has committed any crime. But because he's a citizen who has a responsibility, a duty to ensure that justice is done in these matters, and there's a likelihood of the commission of criminal activities in the 5 named areas which criminal activities touch and concern him. If he fails deliberately to appear before the investigative bodies to assist in investigation, will be a fugitive from justice. So, and if he's a fugitive from justice, the only course of action open to the investigative authorities is to declare him as a wanted person.
I see, but if the OSP is so desperate for information from him, why doesn't he go to the US to talk to him? If the man says he can't come to Ghana because he's not well.
They are not asking for information from him. They are requesting him to assist in investigations. OSP already has a set of informations.
Okay.
And there are presumptions and hypotheses, which seems to be pointed in a certain direction. But that is what their preliminary investigations have revealed to them. Can he successfully respond to them? If he comes and he's unable to successfully...
No, there's a question. There's a question for you. He's asking a question. Ask the question.
Does he necessarily have to appear before them in person? No. The answer is no. He doesn't necessarily. He can even speak to them on phone. He can engage in video link with them.
So
if there's no law that says that he must appear in person, there's no law anywhere. So let's be very clear about this one. It is because that has been the norm over time. But in this era of digitalization, you can't use, the absence of a person as a basis to say the person is unreachable, when indeed there's a way that you can meet the person. Of course, what they can say is that they want to be able to engage him without and they should be able to see who is behind him, probably giving him information to answer the questions and so on and so forth. Maybe you can say that, but that means that you can move to the locus. And your question is very, very important. They have every opportunity under the Mutual Legal Assistance Act to travel to the United States to engage him physically and then bring the evidence and then start your processes.
So, Idrissa, what's your response to that?
No. So, first of all, you just read Article 14. I don't think the words there were put there for fanciful reasons. A person arrested, restricted, or detained. So if Ken Ofori-Atta were in this country, or Wontumi arrested, now his movement has been restricted in the sense that he's been granted bail on certain conditions. So that's the restriction. That's the police, the exercise of police powers. What you are talking about is not the exercise of police powers. When you talk about police powers, they are powers of compulsion to prevent you from committing other crimes, to compel you to appear from them. That's why we have criminal summons. To compel you to appear. You are in the jurisdiction. But the criminal jurisdiction of Ghana is territorial in nature, except where it is backed by reciprocal arrangements.
And we have them. It's a Mutual Legal Assistance Act.
So, but the mutual legal assistance is different. What I'm talking about is simply that the whole world is united against terrorism. So if a person commits terrorism in Ghana and runs to another country, and that country is a signatory to a mutual legal assistance, that country has a duty to assist Ghana to get that person back to Ghana to stand trial. Or crimes against humanity. You know what? That is why in the United States of America, that crime or the crime of terrorism is of universal application or universal jurisdiction. So this is different.
I see.
Let me read something for you. Maybe it will give you.
We have 2 minutes, so let's make it
under the
snappy.
the Mutual Legal Assistance Act. Section 5 says that scope of requests: a request for mutual legal assistance in a criminal matter includes a request for assistance to identify and locate persons, to examine witnesses, to serve judicial documents, to execute searches, arrests, and seizures, to examine documents, objects, sites, for transfer of proceedings, for the prosecution, intercept communication. So there is a legal foundation for this proposition that I'm making. I mean, because the lawmaker is aware that we may have a situation.
No, he wants you to explain. It's legal foundation for what?
Legal foundation for what?
Legal foundation for engaging Honorable Ken Ofori-Atta in the electronic engagement that I'm talking about. Because the lawmaker is aware that the...
he was reading... He was
where's
reading...
that foundation in the law that you just read?
Say that again.
He says, where's the foundation in the law
that you just read?
Oh, but you look at this. I'm talking. That's why I took you to the scope of requests.
Legal,
and we are talking about criminal. It makes specific reference to criminal proceedings. We're not even talking about civil matters.
I agree.
So you are tying the hands of the OSP, but the law has freed his hands so that he will be able to do his work without saying that I couldn't get the man.
Let me hear him briefly. Yes, go ahead.
What is the legal foundation for the electronic conferencing for mutual legal assistance? What is that foundation?
Let me read it for you. In section 40, request for hearing by means of technology. And with the permission I read, if a person has to be heard as a witness or expert by the judicial authorities of a foreign state or a foreign entity, the central authority of that foreign state or the competent authority of that foreign entity may make a request for a hearing by video conference or any other means of technology designated by the minister.
And what's the name of this document?
This is Mutual Legal Assistance Act of 2010, Act 807. And
No.
it provides again evidence gathering by video conference. That's under section 41. Section 42 provides that hearing of accused persons by video conference.
So you think the OSP has
there is sufficient
and this is a
grounds.
Ghana law?
These are Ghanaian
2010.
laws. You understand? So what Mbe Inusa is saying is tying the hands of the OSP. Now the law has expanded and strengthened his hands.
No, but let's think about what the OSP is doing, not what Inusa is saying. So is OSP tying his own hands?
So OSP is tying his own hands. He has every opportunity to move beyond, the office of the OSP, to go anywhere in the world, to enforce.
Maybe he has to
laws.
Explain to us why he prefers to have.
First of all, can I come in?
You have 30 seconds. We are wrapping up, so come in and we close.
So first of all, the first section he read was video conferencing of witnesses and experts
and accused persons.
That's the first one.
An accused person.
The second one he read was for accused persons. Ken Ofori-Atta is neither a witness or an expert witness. And he is also not an accused person.
I think this is a matter of semantics.
So he's being investigated
no,
for
not
now.
Semantics.
He's being investigated.
It's not a matter of semantics. It's not semantics.
So what is he? He's a person of interest.
An accused person is a person who has been charged with an offense, not so.
So he's a person of interest.
He's a person of interest.
So until the law explicitly states that a person of interest can go through this process.
Offense, how does he become an accused person?
All right, I think we can leave it here.
Yeah, he's not accused of any crime, has he?
Not yet.
Not yet.
Thank you, sir.
So what are you talking about?
We have to end it. Otherwise, I'll be accused of causing loss to my station. Alhaji Inusa, it's good to see you. Thank you for talking to us. We wish you well. Hope to see you soon in the flesh. And thank you so much. He is doing video conferencing.
That's exactly. You are taking full advantage of video conferencing
from his living room.
You don't want the OSP. Look at the very nice living room just that he's sitting on. This is my senior brother. Let Ken also have the benefit of the election.
Hassan Tampuli is MP for Gushewu. Alhaji Inusa Husseini is former MP for Tamale Central. Thanks for watching. For want of time, we'll have to end it here. We'll see you next time. Have a good evening. Bye-bye.